VP of Attorney Services, and I think I know a fair number of you already. If not, come say hi. I apologize in advance. I just got back from London last night, and I'm extremely jet-lagged, and if I'm stumbling over words and sentences, that is my excuse. No alcohol for me tonight, caffeine. So, but I got asked to do a rather last minute, should I stand behind the mics or the speakers, or are you? Yeah, okay. I got asked to do this rather last minute, so bear with me, but I wanted to give you a quick overview of what LegalZoom is. I actually see some former Zoomers as well as some current ones in the audience, so bear with me, folks, and feel free to chime in if I get something wrong. And yeah, after that, we'll do, I think, a pitch, mini pitch competition with how many companies? It's 4, 5? Perfect. And then we're doing Stephen is doing a overview of his company, which should be exciting, and then a panel. Okay, well, we'll get to that. And then we'll do a quick networking thing at the end so that you can make sure that you meet some other folks. All righty, and with that, we'll get started. So I would guess most of you know what LegalZoom is, but just in case, I stuck it up anyway. We've been around for a while. I'm not sure how many of you have been to our offices before, or if you have been in our Hollywood ones. So we are a technology platform that gives access to legal solutions, basically. We have started over 1 million companies, and we've done over 500,000 attorney consultations have been requested. And actually, Mark Ruskow, who's in the audience, is one of our partner firms that we work with. And I think your firm has done, what, 150 of those? Yeah, 150,000, that is. So, small number. And the stat that always gets me is we do a will every 4 minutes, which is mind-blowing. That's quite a lot of wills and trusts. So our brand is actually 70% recognition with people over $50,000 in income, which is a crazy number. And I think Scott, you're in the audience as well. Scott used to be here in our marketing team. And he can attest to that's taken a lot of time and money to get there. But we have managed to reach it. And you can see the progression over the years has been pretty impressive. So this is the slide I like the best because I think it's representative of what LegalZoom is and what legal tech is. There's a thing, and apparently my colleague said this was a focus of Codex last week, the whole concept of lawyers versus non-lawyers. And I mean, does anybody call a doctor versus non-doctors? Nobody really says that, so it's a little weird and specific to the profession. And we all know why it happens because of the regulatory restrictions. But I think the wonderful thing about legal tech is it allows lots of different people from lots of different backgrounds. I'm looking around our colleagues in the room, and we've got product, we've got tech, we've got legal, we've got, who else is creative, UX, I see JC. And being able to work with lots of people, different people of lots of different backgrounds, I think actually makes the products better and stronger and the experience better for our customers. And I can honestly say it's a lot of fun as well. It's very different than your traditional law firm, that's for sure. But it's really wonderful. So we've evolved quite a lot over the last 17 years. And as you can see, we started off very much as an online document service and have evolved. And I don't know how many of you know the original story of how the Bryans came to work with Robert Shapiro. For those who don't, basically involved a late night call on an off chance that he would be available. And I don't know, there's some other people who've been around longer than me, but basically, they called him up on a whim, and he actually answered the phone. And they said, give us an opportunity to pitch. He said, you've got 2 minutes. And they did, and the rest is history. And he came on board as a spokesperson and really helped evolve the company. And then in 2010, we evolved again and went from pure legal documents and started to incorporate lawyers. Case in point, Mark's firm in California. And I think, Mark, you have the mitigated pleasure of doing the first attorney consultation? First one. And how did that go, Mark? So LegalZoom, we rate the attorneys, which, needless to say, isn't necessarily the most popular thing for them. But once they get used to it, I think they actually like it or tolerate it. And I think your famous response was, oh, what? You want me to be nice to the customers? So it's been a culture shift, shall we say. But
God was ultimately released on appeal, right? He didn't actually go to the gas chamber. Right? The story has something of a happy ending, right? We don't do violence.
that's not covered under the legal plan, Adam. You should know those. Come on now. And then more recently, we've kind of evolved into new markets. And in I believe it was 2015, we were the first a U.S. corporation to get an ABS license in the U.K. We actually now own a law firm in the U.K. And beyond that, we will have to wait and see what else happens. So rewinding just a moment, I wanted to share with you this. This is what our website used to look like. And I see JC, who's our UX guy in the back, sort of squirming uncomfortably, going, oh, avert my eyes. But this is what it used to look like. Now, it's pretty basic, and for 2001, it wasn't too bad, but this is what it now looks like. As you can see, a little bit different. I'll get out of the way. And you can see that is kind of indicative of how the company has evolved, not only just in terms of how we present things, but also the number of products that we do. So, and I got this slides from our creative team, and advertising. So advertising used to be easy, but now not so much. So we also have to target all those customers to get that 70% brand recognition in multiple different ways. So it's a lot more complicated. And one of the things that we started doing, what was it, Scott, was it back in 2012? We started doing podcasts. Yeah, and LegalZoom was actually one of the first companies to really take advantage of it, and we had really great traction with it. So we advertise in many different shapes and forms, and also on many different platforms. And since you've probably had enough of me talking, I figured I'd show you some of our new creative, because obviously when you try to appeal to your customers, you have to know them, and you have to talk to them on their level, not in a lawyerly fashion. So we've created a few new commercials. You may have seen them, but they're pretty cute. So with that, I will let...
This is Laura, and Butch, and Tank, and Tiny. And this is Laura's Mobile Dog Grooming Palace. Laura can clean up a retriever that rolled in foxtails, but she's not much on articles of organization.
Articles of what?
So she turned to LegalZoom.
They help me out.
She means we help with her LLC, trademark, and a lot of other legal stuff that's part of running a business. So Laura can get back to the dogs.
Would you sit still?
This is Laura's Mobile Dog Grooming Palace, and this is where life meets legal.
So as you can, I figured worst case scenario, if I tanked this, put cute dogs up, what else can go wrong? But I also included one more because this is my personal favorite, and unfortunately, we did a couple of different takes, and the one I really liked ended up getting cut because the actor was ad-libbing, and it was hysterical, but it was deemed too controversial. So you're getting the more PC version, but it's still pretty funny. So with that.
So I needed legal advice, and I heard that my cousin's wife's sister's husband was a lawyer, so I called him. But he never called me back.
If your cousin's wife's sister's husband isn't a lawyer, call LegalZoom, and we'll connect you with an attorney. LegalZoom, where life meets legal.
All right, and with that, I will shut up and let other people take the floor. And forgive us for a second, we're going to switch over computers, but bear with us for 30 seconds a minute, and then we'll get started. So use this opportunity to go grab another drink if you need to. There is water, and there are water machines if you need non-alcoholic beverages.
Thank you. Thanks everyone for coming. So my name is Arya Safar, and I am one of the organizers of Legal Hackers. If you don't know what Legal Hackers is, it's kind of like life hacking the law. We don't hack into computers or anything. So it's pretty technology focused because we see that that's a way to make the law much more efficient and accessible to people. And so what we've been doing for the last few years is have a demo night where different legal products come up and talk about what they're doing and hopefully give you some inspiration for either improving your practice or for starting your own thing, whether it's a product or a service or whatever. So with that said, what we're going to do is have 5-minute pitches from 5 different companies. And I'll be pretty strict about time, so I'll do the 2 and the 1, and then I'll cut it off at 5. And I think the first presentation, Michael, you don't need a deck, so you're good. But otherwise, I will pass it off to you, and we'll get started. Thank you.
The tech company doesn't need any tech material, so it's kind of ironic. Just before I kind of start, depending on how I kind of give this presentation, I kind of want to get a feel for the room. Raise your hand if you're a lawyer. Oh wow, a lot more than I thought. Raise your hand if you're like potentially starting a legal tech company. Raise your hand if you work at LegalZoom. Okay, there you go. Or used to work at LegalZoom. Okay, awesome. So actually that last commercial you gave where my cousin's brother, sister's, husband's, wife, whatever it was, didn't call me back is a perfect segue to the company. But before I kind of talk about what Lexicata is, I think because a lot of you guys out there want to start a company potentially, I think, and also if you're a lawyer, a lot of you guys are entrepreneurs as well. So I think it's always interesting to hear the story of how things come about while talking about the company itself. So about 5 years ago when I was at Loyola Law School, came up with the idea for a company. What the idea was is pretty irrelevant to the story, but basically what happened was we had that exact same experience that guy on that commercial just did, which is, oh, you know, how do I find a lawyer, right? And we thought that was pretty ridiculous coming from 2 law school students who were trying to start a company that we were finding difficulty finding a lawyer that we want to use. So essentially what we did was we came up with a legal tech company called lawkick.com. Basically what that was a marketplace to connect lawyers and clients together, right? An easy way, kind of like a TaskRabbit or Uber for a driver, Uber for the lawyer. 2 major problems came up, right? So it was going well for a little bit. We raised a couple $100,000. We got a bunch of clients using the platform, and basically we were figuring out that the clients weren't hiring the lawyers. So we went to the lawyers and we asked a couple questions, right? So we went to the clients actually first and we said, so why aren't you hiring these lawyers? And we ended up finding out that they actually were hiring lawyers, just not the lawyers on the platform. And we asked them why. They basically said, well, I would end up talking to lawyers and they would ask me for a paper intake form or send me a PDF that I had to print or I have to come to the office or pay with check. Basically, effectively, what we realized what we created was a really crappy Uber where you could order a driver, but then they asked you to pay with cash at the end. So it was a friction-filled process. The second part were the lawyers, right? People like Mark, or like the first person, well, better than Mark. So basically, people who would call a lawyer and then the lawyer wouldn't call back. Very common story. The #1 complaint by all clients pretty much across the board for most bar associations is lack of communication. I don't hear from my law firm. So they would end up saying, hey, I messaged the client and they never hired me, so I'm done, right? And we thought that was absolutely mind-blowing because you know, these are literally free clients. We weren't charging for the platform. So essentially what we asked them is, what are you using for sales, marketing, and client intake? And we realized that they were pretty much using nothing. So enter Lexicata. Essentially what we are is the #1 CRM and client intake software. We basically focus on anything from the time that you first meet a client or introduce to a potential client to the time they actually retain that client. So we help with everything from email marketing, relationship management, nurturing those leads, nurturing your referral sources as well, your referral partnerships, other lawyers. We also help with things like online intake forms. So instead of having your clients, you know, fill out things on paper or PDF, You can go with the new school way of sending them a hyperlink that they can fill out on their phone, tablet, or computer. We also, like I said, do email marketing. So if you meet someone, like I said, on lawkick.com, and then they don't hire you on the first whim, well, you can kind of keep them in your funnel, continue to market them, continue to put yourself in front of them, continue to make yourself more likely to get hired eventually. We also do things like workflow automation. So you can do things like automate documents, engagement letters, fee agreements, letters of representation, letters of non-representation, all that kind of stuff. And we also have e-signature built into the platform. So essentially what we've done is we've built an end-to-end solution, essentially a pre-case management platform. Out of curiosity for the lawyers out there, how many of you guys actually use case management platform? So a decent amount of you, but a lot of lawyers in the industry use case management. Essentially what Lexicata has become is pre-case management. Most people have neglected the business aspect of their law firm, so that's essentially what we do. Over the last couple of years, we've blossomed into a very successful company. We have thousands of firms who use us across 21 countries. We process over 20,000 fee agreements a month through our platform, and we do over, I think it's over like 200,000 intakes in a given month from people across our platform, including the one and only over here, Mark. And that's essentially what Lexicata.com is.
Thank you. Yep, we got it. Left and right. Oh, great. And actually, is it up and down? Is it not working? You did the old-fashioned way if you want, just left it right there.
So you're doing 1 minute? All right, hi everybody. My name is Ian Schick, and I am the CEO and co-founder of Specifio. Before this role, I was a practicing patent attorney. I was at Pillsbury, Winthrop Shaw Pittman, and practiced for about 10 years. I started this company with a former client of mine, a fellow named Kevin Knight. He's a professor at USC and world-renowned expert in artificial intelligence in the specific area of natural language generation. There we go, PDFs. There has been little advancement in patent drafting technology since the advent of the word processor. Oh, thanks. Patent applications are 20 to 30 page documents that explain what the invention is and how to make and use it. They're written by legally trained engineers, and the fees for these are generally flat feed, so that they're not hourly like many other legal tasks. The volume of patent applications has been steadily increasing. The curve kind of looks like this, if the elbow is around the mid-90s, and we're up here somewhere. Okay, cool. And in the past 10 years, the number of licensed practitioners has been cut in half, actually, new people taking the patent bar exam. So enter Specifio. We are not a replacement for attorneys. We amplify their talent, however, using automation. So patent applications start and end with the attorney. Attorneys complete about 20% of the project. We automate the middle couple thirds, and then it's polished off and sent to the client for review. This lets attorneys focus on more profitable areas of their practice and push more work through their practice. Our service does not require any installation of software or new tools. We run our service over email. So the way that it works, a patent attorney will attach a Word document to an email that contains patent claims. So these are a numbered list of sentences that very precisely lay out what the invention is. So this document is prepared by the attorney, sent to our automated system, and literally 2 or 3 minutes later, they get a reply email with a 80 to 90% done patent application with figures. So we can turn a couple pages of attorney-written work into 20 or 30 or 40 pages, literally in a couple of minutes. Our applications include explicit support for the claims, so a direct description of the invention, as well as computer-generated content where our system is identifying key concepts in the claims and expanding on those. Our documents can be personalized, so you can get our auto drafts to look a lot like your own work. So that helps with adoption, it helps with avoiding work product discontinuity. On the confidentiality and data security side, our system is fully automated. So that means no one on our side sees the confidential information. Documents are received by us and sent in encrypted format. The encrypted documents exist on our system for about 2 minutes, and they're permanently deleted. And we do not perform any machine learning on our confidential information that we receive from our customers. Our product roadmap. So we're about a year into it. In this period, we have focused on patent applications in the software area. So that's about 20% of patent applications that are filed. We're expanding to new domains over the next several months, and we'll expand to other languages and eventually other documents in the patent life cycle. So the patent market is about $6 billion per year. Our addressable market is around 500 million in the US alone. Multiply that by about 3 if we cover the top 5 markets worldwide. Our go-to-market plan is land and expand. So we get into law firms, get a couple users, and then do webinars basically to expand on that. So in summary, Specifio provides a revolutionary disruptive product in the patent market. Our founders are domain experts and technical experts. And by the way, we've got about 30 patents on file written by our system, covering about every aspect of what we've built. And we're currently raising up to $2 million. Perfect. Thank you.
I gave you some extra time on that. Yes, okay. Now that I've learned all the stuff that goes wrong. Denise, all right. Now it works.
Hi, my name is Denise McGettrick, and I am founder of PassRight. PassRight is the first nationwide brand of technologically connected immigration law firm services. PassRight signifies to me accessibility, connection to experienced attorneys in immigration law, as well as a handle of empathy, because immigration is an area that really needs it because it's so tough. I've been practicing immigration law for 14 years. I was practicing at law firms for over 10 years. I was at places that didn't embrace technology. I was at places that didn't really care about it. They didn't really think that it helped their business, but I thought that it did because I was seeing all my colleagues in the business world utilizing technology, and it was helping improve their businesses, improve their connection with their clients. I knew that there was a better way. So I started my own firm, and I never looked back. PassRight allows me that ability to strategize with my clients. I focus on business immigration. So that means that I strategize with employers, employees, as well as any other stakeholders that are interested in this person gaining the work authorization that they need to do to be able to do the work that they need to do. So I put everyone on the same plane because everyone has different expectations. The employer has an expectation of what the immigration process entails. The employee has their own expectation. Other stakeholders have their own idea as well. I strategize to put them all on the same plane. And it's tough, but you can juggle it. I also understand the issues that my clients go through. Getting yourself, as well as your family, moving yourself from your home country to the US is an incredibly difficult endeavor. They are being pushed by their employer to open an office in the US. They're either a founder of their own company and they have their baby and they're being pushed by their investors to get the work visa to be able to continue to create their child. It's incredibly difficult for them. And they're getting all of these different ideas from their colleagues, from their friends, from the media, from the messages that you're getting from the administration that are not very welcoming. And that itself is very difficult to swallow. So I absolutely understand what my clients are going through, and it's important to have that empathy that I was talking about. PassRight is a digitally enabled full-service law firm. Before I was with PassRight, I had all these administrative tasks to do. I had to exchange emails with clients. When would you like to meet? You know, what is your issue? So it was a back and forth. And people have these needs. They have this business that has to go up. They have this office that needs to be opened. I am able to eliminate that with PassRight. PassRight allows me that ability to just set it aside. I'm able to engage with my clients. I'm able to speak with them one-on-one. What is the problem? Tell me what's going on. PassRight is just an incredible endeavor, and I'm so happy to be a part of it. I am able to speak with potential clients much more often than I was as a solo prac. I can sign up 6 more times clients than I was able to before. It's just an incredible, scalable endeavor, and I'm so happy to be a part of PassRight. And it's amazing to be here to talk with you. Thank you so much.
Hi, everyone. I'm Nick Brestoff. I'm the inventor, founder, and CEO of Intraspexion. Intraspexion is a combination of intranet and doing things to enable corporate law departments to be introspective about the data to which they are closest. So it's a patented deep learning software system to enable those lawyers to know about the risks of litigation before the lawsuits. So let me give you a quick very high-level idea of what deep learning does. With a category like civil rights employment or civil rights jobs, but it's PACER, Nature of Suit Code 442, and the correlated data for that category, namely the factual allegations in complaints filed for civil rights employment or jobs, you can train an algorithm, and essentially it's like putting a bunch of arrows in the bullseye, not hitting it from afar, but walking right up to it and saying, boom, 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 boom. Here's 400 examples from factual allegations of previously filed lawsuits in that category, discrimination. Now you understand what I'm looking for. So it's all about a computer that can learn. The next thing is, and this is actual data, you have to have a positive set and a negative set. The negative set is essentially New York Times articles or Wikipedia articles or 10,000 emails out of Enron, which have nothing to do with discrimination. And you can see that there's a little group of red dots in the lower left-hand corner. That's 400 examples of factual allegations out of discrimination lawsuits. So that's the positive cluster, so to speak. That's the training. Now what you want to do is look at emails, let's say from yesterday, and find the risks. So I know it's a little hard to see, but in the lower right-hand corner, we've looked at, the only data I can tell you about is from Enron, right? Because I can't tell you confidential customer information. 5,000 emails, the algorithm surfaced 24 and said, hey, look at these. That's 0.5%. We're actually better than that now. We're down to about 1/8 of 1%. This is, then you get the score from the algorithm and a line of text, and you get some subject matter expert curated words just for visualization purposes. Now the cool thing about that one, whoops, what did I do? The cool thing about that one was that this phrase was in that first high-scoring risk. My employment is to be terminated. No job action yet. So no damages, no lawsuit. If a paralegal or attorney can see that early, then you can go through and check true positive, false positive, and that would be a true positive, of course. And then you can open that email, because we index all of them going in, and see the PST in its native state. That's where the in-house team can start an investigation. And once the investigation is complete, then they can advise a control group executive. That keeps work product and attorney-client privilege in place. We've been noticed. We made the initial list of legal AI leaders that was published by the National Law Journal on February 1st, and it's patented. And that's my story.
Hi, everybody. My name is Amy Wan. I'm founder and CEO of SageWise. Who in here knows what a smart contract is? Oh, that's a good number of people. So for those of you who don't know, a smart contract is basically, it can be a contract basically written in code. It's basically if-then clauses. So I'm going to tell you a funny little story. Last year in 2017, over $1 billion in value was lost in smart contracts. The cryptocurrency markets were going crazy. People were raising all this money from ICOs. But the strange thing is that every other ICO, initial coin offering, that popped up online was basically getting hacked in its first 15 minutes. The founders were losing $2, $3, $7 million from these hacks, and they would sit there, shrug their shoulders, and be like, oops, sorry, there's nothing we can do because smart contracts are self-executing and immutable. So what we're doing is we're basically creating a safety net for smart contracts. Smart contracts are not smart. They're dumb, right? You've got coding errors. You have security vulnerabilities. People genuinely will need to amend, modify, terminate, and dispute their smart contracts. So what we created is an SDK. It's a software development kit. It's basically an arbitration clause in code. You copy the code, paste it into your smart contract just like you would your arbitration clause, and it sits there. And to the extent your smart contract is executing in a way that the parties do not intend, you can go trigger that SDK. It will then freeze execution of the smart contract and give you the ability to go ahead and actually resolve whatever it is that you need to resolve, whether it's fixing a coding error or actually resolving a dispute. Now, why are we creating a safety net and a separate dispute resolution marketplace for smart contracts? Because if you actually think about it, if you take a smart contract dispute through the traditional legal process today, it's either impossible or really just does not work really well. A lot of smart contracts are done pseudonymously, which means you're actually cut out of the traditional legal system. There's no one to name in a complaint, no one to serve a complaint to. Even if you can get across all those identity issues, while the traditional legal system can help you come up with a judgment or resolution, they cannot help you with collections and enforcement. And for those of you who don't know, a smart contract can basically act as a digital escrow, right? The traditional court system doesn't have that technical capability to help you with the collections enforcement. And even if they hired that third-party technical capability, the problem is then your technical folks are basically stuck there trying to hack your smart contract, which really doesn't work very well. Our target markets, we actually have 5 of them, but they're financial services, insurance, supply chain companies, the digitized asset market, and consumer marketplaces. My co-founder and I are both startup veterans. We both come from the fintech industry. I used to be general counsel of a real estate crowdfunding platform called Patch of Land. He has been VP of engineering and CTO for the past 5 years at various companies. The last one was a registered investment advisor fintech company. We have an amazing set of advisors, everyone from the former director of dispute resolution from eBay PayPal to Dr. Jillian Hadfield, who's actually on the board of LegalZoom, I think. Yeah, and she actually advises the World Economic Forum on legal infrastructure. And that's it. Thanks.
Thanks, everyone. And if you want to see any other events that we have, you can find us on Meetup. Just type Legal Hackers Los Angeles. And I think we're on to the next event. Steven? Oh.
Oh, really? Assist.
Wait a second.
Oh, wait, yeah. I know.
Watch out.
If we put it to present. No, I don't know. Just a guess. Yeah, right. Maybe if we do it
Yeah, try slides.
from. Ah. I don't know. Hi, everybody. First of all, I want to thank LegalZoom for having all of us. Thank you very much. Yeah, and for the great food and drinks. Portos, never have to wrestle me to eat that, and so nice choice. And I do want to say thank you. I mean, I think every single person here who has a startup that's not LegalZoom, and LegalZoom's not really a startup anymore, but still innovative in a lot of ways. I think that we all stood on the shoulders of giants. I mean, they fought battles for us that paved the way for us to do what we're doing. And when they got started, nobody was doing anything close to being online, period, let alone law. So pretty incredible that we're here, all working together. I think we probably have most of the legal geeks in LA in this room, right? If you think about people who are interested in law and tech and who can make it to Glendale at this time, I think this is a pretty amazing crowd. So thank you all for having us. I'm Stephen Kane. I'm the founder and CEO of FairClaims. Going to tell you a little bit about who we are, and then we're going to do a short panel with some of the folks involved with FairClaims. Our mission is to improve access to justice, period, and make it easier for people to resolve disputes. And our vision is a world as free from unresolved disputes as possible. And because disputes have real costs, they're stressful. Even if it's a small dispute of $2,000, $3,000, that can weigh on you. That can mean the difference between making rent or not, as we've heard from some of our users who have used our service. And they create nastiness in the world. I mean, if a neighbor doesn't resolve a dispute with a neighbor, maybe that leads to a fist fight. You know, if you don't resolve a dispute with a company, it leads to resentment. It's all these negative psychological effects that aren't as tangible as maybe other problems, but are very real. And then there are all the economic impacts of making it more difficult to do business if you can't trust the other side because you're worried about there being a dispute you won't resolve. Or just plain old feeling terrible when you know that you're owed money and you're not able to get it. And part of the reason we started FairClaims is I'm a lawyer by background, and I kept getting calls from people with disputes they couldn't resolve. $2,000, $3,000, unpaid invoice, small breach of contract, a landlord-tenant security deposit issue. And it was terrible to tell folks I couldn't help them. My fees were too expensive for them to get resolution, and they did not want to go to small claims court. I mean, especially if they had been to small claims court, right? It sounds terrible to anybody, but if you've been, then you know it's terrible, right? You wait 2-3 months, you have to figure out how to file paperwork, serve the other side. You might have to take half a day or a full day off work or from being with your family. And then you only collect 60% of the time. So that's the whole idea behind it. And I beat us to the slide punch, but it's true. Disputes cost too much money, take too long. It's a problem that's obvious to everyone. And you have really just bad choices. Paying someone off, hiring expensive legal counsel, or just letting it drag on. So this is our software. It's sort of like a TurboTax, but for resolving disputes. And people can see where they are in a dispute resolution process. So we use digital arbitration and smart settlement tools and mediation to resolve disputes under $25,000. And you get an arbitrator assigned, you get a hearing scheduled, you upload evidence, you annotate the evidence, you have a live half-hour video hearing, all remote, and we resolve these disputes in 3 weeks. Whereas it used to take 3-4 months, cost money, take time. Now it's all in 2 to 3 weeks on average. And then this is to give you a sense of what it's like when you're in a video hearing. And what I love about this is a couple who hired a professional service provider. The pro, as we call it, is on a mobile phone, like sawing or something, like working, right? It's amazing. We've had people arbitrate in cars, and I know that we've made legal history when we did that. Like, it wasn't safe, but one of the first arbitrations we ever had, the guy was in his car. He had a little baby in the back, so we really wanted him to pull over, but it was not good, but it's amazing. So these people sometimes are working, and they talk when it's their turn, and you can see, like, how difficult it is, you know? And this happens to have been a dispute that arose for work done in their home. And so that's really personal, right? I mean, that's where you live. And before, these folks couldn't resolve these issues easily, right? They had to either hire a lawyer or go to court. One of my favorite stories is a woman who lives in Wisconsin, went through a marketplace we work with. So we work with Home Advisor, Turo, companies like that, right? About 30 of different marketplaces. And she hired a professional on that marketplace, not Home Advisor. Her friend hired the same pro, and they both had an issue. He skipped out on doing any work. Her friend had to hire an attorney, was still waiting on even like filing paperwork when I talked to her. Meanwhile, she had recovered $4,000 through us, paid for by the marketplace. And she said, look, I don't trust the courts. I wasn't going to get a fair shake there. It's about who you know. The rich and powerful are the ones who get the fair shake. And I did get a fair hearing through you. And she got her money back. And she said also, I'll always use that platform because of you. And that's the kind of stuff we really live for. This is our smart settlement tool. It's a combination of some automated messaging, some early AI that we're going to keep building out, some predictive analytics on the other side that tells people, here's what you might consider settling for, and here's your chances of success on one side. You can chat to the other party on the other side, upload evidence, get a mediator on demand. We resolve these disputes in 5 days on average, 50 to 60% of the time. And these are disputes that used to drag on for 30 to 60 days at least through marketplace customers of ours. So we work with sharing economy marketplaces, but insurance companies now as well. That's the claims dashboard for the folks at the company to manage all the disputes in their queue. And just a little bit on how it works. Some of our customers here, so Peer Space, we have a partnership with the Better Business Bureau, and we work with Honk as well. We did I'm a fellow at Stanford Codex Center, and we did a study on taking arbitration mainstream. And the idea is arbitration's been something for the big companies for decades now, but consumers haven't used it. And in fact, it has a bad name when it comes to mandatory arbitration between a big company and consumers, which is a whole other topic, but an interesting one. I think it's difficult to have empirics on that topic and figure out what's actually going on. But we want to take what companies have used and give it to consumers. So the thought is, if we're going to do that, if we're going to take things mainstream, we really need to understand that dynamic, and we need to figure out how are we going to get people to opt in voluntarily to arbitrate on demand. Most people don't know what arbitration is. Maybe if they're a sports fan, they have some sense of it, maybe. But they don't know what arbitration is. They don't know who FairClaims is. And so part of what we do is educate them on that whole process, and we've seen a very successful opt-in rate through our partners. So it's something on the order of between 65 and 80% of people opt in when invited through a partner of ours. And so we did this study to figure out a little bit more about it, interviewed attorneys, interviewed end users, used some of our stats. So there's some preliminary findings I want to share, and then we're going to invite one of our end users who did voluntarily opt in to join us on a panel, one of our arbitrators, and then somebody else from FairClaims who manages some of the mediation arbitration to talk about it a little bit. And I think that'll be interesting to hear from a non-lawyer and a non-legal tech founder something about this. So we wanted to answer, what helps move the needle? Like what gets people to sign up voluntarily after they know what arbitration is? What messaging works? What demographics might matter? Here's some of the basics of what we found. When you just politely, pretty please invite someone to arbitrate, it don't work. That's not a shock, right? And usually it's when you're inviting somebody, the respondent or whoever owes money, and they get an email and they don't know what it is, and there's a lot of issues with it, but very low conversion rate. When there's some sort of stick, it's a much higher conversion rate. And so what we found that worked is not only the threat of small claims court, but actually filing small claims court paperwork. It's a very different dynamic once you have to show up in person to court. Then you're a little more willing to look at what FairClaims is about. So it's more like a 30% conversion. When they know each other, this one was really interesting. For some reason, one week we got like 3 roommate disputes in a row. And they were fighting about money owed to each other, deposits, stuff like that. We also have a company we work with called Bedley. That's like modern corporate housing. And they're dying for us to help them with they get 5, I shouldn't say, they get some, they have people who live together and sometimes there are disputes. And dirty dishes, whatever, anybody who's had a roommate's had issues, and they want us to use FairChat to resolve those. But when people know each other, there's much more likelihood that they'll agree to arbitrate or mediate, and that makes sense. And mediation's been useful in family law. And so we thought that was super interesting, right? And we think there's going to be lots of application for what we do to roommate disputes, business partner disputes. My girlfriend is dying for me to use FairChat to resolve relationship disputes. And actually, in reality, people are waiting longer to get married, and so there are actually disputes over property and assets and the dog and things like that we could help resolve that aren't finding their way into family court, but still need resolution. So it's kind of interesting. Now, when it's through a partner of ours and there's the right incentives of, hey, you got to be a good citizen on this platform, and we expect you to do the right thing and resolve this dispute, and plus we think it's a good tool for you because the other side's claiming this and that, and you can go and defend yourself, we see a much higher conversion rate. So I don't know, I geek out on that. Now we're going to bring up some people who have been involved in the actual process and chat for a bit. And then after that, we're going to let you get back to drinks and food. No, we don't need that. Wherever you like. Yeah, sure. Thank you. All right. So I'm going to have each of the panelists introduce themselves. John, if you'd like to get started.
I'm John Shaw. I'm a contractor. I have a contracting company in California and Arizona.
All right.
I'm Jillian Hollingshead. I'm an attorney. I worked at O'Melveny for 7 years. left when I had children, and now I do freelance work as well as serving as an arbitrator with FairClaims.
My name is Tanaz, and I'm a legal analyst at FairClaims, and I help a lot with the operations.
All right. So John, my first question is mainly for you, which is what was your experience with law, disputes, things like that before being introduced to FairClaims?
I've been doing this for 37 years, and as a contractor, we deal with homeowners and customers that sometimes can be unrealistic and very demanding and turn things all the way around on you. And to go to attorneys, which we have full-time set up, but it's very costly. Your company really helped us. It resolved it very quickly. Within a couple of weeks, we resolved. And I know that I was in the right, couldn't get the homeowner to see that they were in the wrong, and I know everybody thinks they're in the right, but I know that I was, so I said, you know, this is ridiculous. And I know it was going to end up going to a court because there was no talking to them. So with FairClaims getting involved, it got resolved. They seen they were in the wrong. It all went to my favor, which I was very thankful, but I know it was going to. But there's a lot of contractors don't do things right, but I have to say there's a lot of consumers out there that can really drive the contractors crazy as well. So.
Yeah, now my brother's had a business for 30 years. Consumers screw over business just like business screws over consumer. That's why you need court. That's why you need dispute resolution. So no question about it. So Jillian, I guess what would be interesting to know is what sorts of litigation and disputes you've worked on in your career, and then also as an arbitrator.
Got it. In my career, I did business litigation, so I did, we represented companies, big companies, so very different from what I'm doing with FairClaims, but just breach of contract, fraud. I did a lot of professional liability, took them to trial, legal malpractice. I also did international arbitration, so I had the experience, took myself overseas quite a few times of working in arbitrations, but the, bigger company disputes. As far as my FairClaims disputes that I see now, I would say you could kind of, the majority that I've seen at least, and it may be different for various arbitrators, but are in two buckets. And one would be, we have a lot of car disputes. We work with Turo. Somebody rents out their car. They don't get, the rent's paid. It's come back damaged quite a few times. The car's totaled. They think that the insurance, the amount that the company is going to pay out is unfair. The other bucket I would say would be construction, renovation, home renovation. And those can be very complicated in terms of the damages. I mean, you have homeowners that are like, I fired him, and there's, I didn't finish paying off the contract. There's thousands of dollars left, and they should pay for it. I mean, they just double up on the damages, and so you have to sit there and look through the photos and what was done, and it's tough. But those are kind of the other main bucket, and then I just get a slew of different unique situations. He was supposed to make a 3D character for my book, and it was supposed to be realistic, but it's not, see? The blueprint that he drew for my home is completely off from what I wanted. I had a legal malpractice. I had a girl going through bankruptcy, hire a lawyer to get, advice on her student loans. So, my pavers were sealed wrong. It's very interesting. It's something new every single day.
Great. Tanaz, you see them all. What would you agree with Jillian in terms of how they break down? Are there other categories you see, just to give a sense of some of the small claims under 25K disputes we see?
Yeah, I think Jillian summed it up perfectly. And then to be a little bit more specific, one specific thing I do at FairClaims is I act as a mediator for Fair Chats. And so Jillian handles a little bit more of the higher dollar value disputes, and so I'll help resolve some of the lower value disputes where users are more likely to come to an agreement, come to a resolution, and so pretty much the same though.
Yeah, and can you give some color on the types of disputes? You don't have to name the companies, but category of disputes in Fair Chat?
Yeah, absolutely. So because they're lower dollar value disputes, they're not as complex, and so they're a little bit more easier to resolve. So for example, renovation, there damages onto a vehicle, there could be, it completely varies.
Okay, great. So Jillian, maybe we'll go to you first on this one, which is what do you see as some of the barriers to access to justice? And in your career, in the different roles you've held, what's your perspective on that, both in big law, international arbitration, and now? And maybe there's issues there that are just as applicable to consumer, maybe not, but I'm curious about how they differ and your thoughts on that.
I mean, I think it probably comes as no surprise that I'm going to say money. Hands down, my feeling after joining FairClaims and serving as an arbitrator is probably, I'm going to guess, I don't know, 98% of these would have just never gone forward, and people would have just, not had a way to do it because either they don't have, the funds to go out and get a lawyer, or the amount in dispute is just simply too low to go. As you were saying, people are contacting you and you're like, this just isn't worth it. And I'm not super familiar with small claims court, thankfully, but I think the filing fees are pretty hefty. You have to serve the other side. There's just so many, that's just daunting. And I think, so financially, people are just sort of like, I don't know what to do. I mean, you see this in family law, I think, a lot, and people who are forced to go through, and they're like, how am I supposed to pay for an attorney? What am I supposed to do? But the other thing that I believe is a big barrier, and you experience this even more than I do, but I'll call it knowledge. I think people just don't know what to do. They don't know how to contact attorney, but even small claims court, what do I do? Where do I file? And the great thing about FairClaims is that there's hand-holding with people, and people need it. I mean, even from me, we fortunately have a process called post-hearing evidence, which I use greatly, and I have to basically explain, start to finish, you have the burden of proof. Here's what I would need. You think that your floor was ruined and you need to redo it? I need at least 2 estimates, explaining how much it's going to cost. And so Tanaz does more of the hand-holding than I do, but if people need that much help and they're given this wonderful platform to have this readily and efficiently resolved, then you can, guarantee that they would never be able to move forward otherwise.
Well put. John, you mentioned earlier in your line of work that things come up, people get impassioned. What has been your experience when disputes arise? It sounds like you're in a position where you have the resources to have attorneys to help, but what's your calculation when a dispute comes up or somebody's complaining? How do you think about what you're going to do, and what are your steps?
First is keeping communication open. Once it goes to the point of actually needing to go to my attorney, at that point it's usually, and then they get something from the attorney, it gets to another level in their mind and things really get to be hectic. That's what happened in the case that I was talking about earlier. I tried everything possible because of doing this long enough. I know it's better just to say sometimes the people are in the right, resolve it, end your dispute, go on, but it doesn't work with some people. And when my attorney sent them a letter that there's a breach of contract, they weren't doing what they were supposed to, they went even worse and ballistic. And we were actually, my attorney as well was threatened online by this person as well as me. And we showed that evidence to the arbitrator for FairClaims. And they pretty much put them in their place, but it went so much smoother and easier than my attorney could have done it, because to bring them to a table and say this is what it is, with the efficiency and the speed that it went, it couldn't have been done any other way. Because to go to the judge and you're in a court, I don't even think a judge would have handled it as efficiently and as well. So that's, it just, you have to keep communication open, and it just doesn't work sometimes. So you're in trouble, and there's no other way to handle it. I was very pleased to find out that there is a company like FairClaims out there to make it easy. I could be at one location, the homeowner was at their home, the arbitrator was at their location. It worked really well, and I was very pleased with all of the success that we had. So, anything else?
I'm curious, you've spent a fair amount of time in small claims court. Can you speak to that experience? I mean, to that, and then also, or I'm assuming, have you?
Some, not as,
Some, okay.
some, but not.
You've been there.
Yeah.
So what was your, this whole study we did was figuring out how can we get people to opt into something like this on demand. And we heard about what Amy's doing with smart contracts, which is outstanding. And so it's a slightly different thing, but getting people to buy into this, in some way where they haven't before, and skipping lawyers. I mean, LegalZoom has done that on the transactional front. And what was the thought there in calculation, and what convinced you?
Knowing that, I was very pleased that the homeowner agreed to do it, because that to me was the key factor. I don't know what caused them to agree to do it, quite honestly. I realized once they did, then I signed up and I said, okay, because I know where it's going and this is going to be so much easier. I've always wondered since that time what was the motivating factor for that homeowner to agree to it. On my end, it was strictly the fact of no matter how it went with FairClaims, even if they said I was wrong, at least this thing was going to be ended. To go to small claims, it does take a month or 2 months, and you do have to serve them, and and that person coming there and you have to be there. I like the FairClaims because I actually didn't have to be in the room with this person and they were at a different location. It was just wonderful. So that helped me a lot. So it really worked.
So that's great. It's funny. From some people who don't sign up, we hear the opposite. They say, I want to be in the room with them. I want to see them squirm. I want to see them get upset, right? So some people do want that, which is not the majority. But the other fascinating thing is that the more time we spend talking to different people about this and about figuring out how to get them to opt in, the more we realize most people do want something like this if they can trust the neutral, if they can trust the arbiter, if they can trust our forum. We're finding that day in, day out, that I've heard from people who say, big companies don't want to do this, they just want to hide behind their lawyers and budgets. We have found that not to be the case. Then I hear big companies tell me, consumers don't want to do that. They want to get a plaintiff's attorney. Sometimes they do, and sometimes that makes a lot of sense. Sometimes that's not the case. So I think it's super interesting. So I have one last question, mainly for Jillian and Tanaz, which is about how this has shaped your view of ADR in general, what role you think it plays and should play, and thoughts on now that you've seen some of what we've done and some of the other presentations, what might be possible going forward.
I mean, I've always been a fan of arbitration. I think we can all initially think that the general idea is you're going to save on costs and you're going to save on time. I don't think that always necessarily proves true. There's flexibility with discovery, but when you're with the big companies and you lawyer up and you have arbitrator fees and you whatever you can agree to it in your contract, but it's not necessarily going to be significantly cheaper. It should be and it could be, but I think when you look at FairClaims, how the online form of it and with the lower amounts, it absolutely saves on costs and saves on time. And when I first heard of the idea, I can remember I was like, that's fascinating. I 100% want to get involved. I think that is amazing, just to be able to help people resolve disputes. And now that I've seen the people and the consumers and the respondents, as I said, most of these disputes probably just never would have been resolved. And so that's, super fulfilling. I think one of the evolving factors that I've sort of keyed in on is the evidence. And we all know that with discovery, whether it's in litigation or even to some extent in big company arbitrations, games can be played. It can go on for forever. One of the benefits, though, hopefully, is that you're getting all of the relevant documents and talking to all of, definitely in litigation, all of the people who have relevant knowledge. Are in arbitration, slightly harder, right? You can't always compel somebody to come, so you're not necessarily guaranteed to have the same opportunity to get all the relevant evidence. And then I think when you go to the FairClaims, that's where we have this post-hearing evidence ability, and it's key to me because the evidence is a lot of people. I can get somebody super savvy who's labeled everything and they've just got it all put together, and I'm like, thank you, because we review all the evidence before the hearing. And then I can have some where I'm just nothing. they've given me nothing, you know, one short statement. And they may have a strong case. And so, you know, the hearings last anywhere from 30 minutes to an hour, and, you know, it just sort of depends. Sometimes parties are emotional and need their chance to state their piece. But it's that evidentiary piece that I think is kind of evolving. And for me personally, especially, I don't always have expertise. You say that he designed your website and it's all off. Sometimes judgment calls come in, which, you know, they can do for a jury as well. But it's important to me, I lay out, I need X. You have, you know, 48 hours to get X as far as your evidentiary support. You have the burden of proof. And I've taken a little bit longer with back and forth with people just to make sure, you know, I want it to be a just resolution, and this is going to be efficient, and no matter what, it's going to be faster. But because there isn't that lawyer representing that side saying we're going to do this and talk to this person, parties just don't always know what they need. They think it's enough for them to come and say, you know, the floor is warped and he installed it wrong. And I'm like, I had a fascinating dispute as one example, and it took forever. Tanaz was ready to kill me, I think. But she, you know, her floor warped. It was installed, her wood floor. His fault. She wanted $20,000. I mean, the amount of consequential damages, this woman was, you know, elderly, needed to be removed out, all these things. And with that amount, I'm going, okay, I need a lot of evidence. And it was very tough because, okay, I can look at the installation guides and I see he failed to acclimate. I understand. But then it came out, you know, you let the wood sit outside in the rain for 3 days in the box. And you were getting, the whole reason the new floor was being installed is you had a moisture problem and the insurance was paying. And I'm sitting here, I mean, I don't normally do this, and Stephen may be mad at me, but I called the manufacturer of the wood.
Amazing.
I actually, you know, I didn't tell the parties that I was going to do it, but I was like, I just don't know enough about wood and installation, and I don't have my expert. I need my expert. You know, I need my expert. And usually the way you get that expert testimony is second contractors come in and look at the work. I always take that with a grain of salt because they want the job. And unfortunately, I don't get to hear from them, so I can't fully assess their credibility. So I typically ask for at least 2 estimates. I want to see the price corroborated. But in this instance, you know, I called the manufacturer. I called Home Depot. I just had to do. And at the end of the day, I fortunately found out you can get this wood association to do a full inspection, and they will be able to determine the cause. Was it, you know, was the wood bad from the rain? Was there a moisture problem that wasn't resolved? And I said to her through this post-hearing thing, this is what you need to do. If you want, you know, you have to do this. She didn't do it. So it was, you know, it helped me in terms of my decision with the consequential damages. But that's just, you know, that's kind of the evolving piece, and it's fun, and I think that FairClaims fortunately has a procedure that I am able to use, and sort of, in a sense, I'm guiding the claimants. If you know, you got to prove this is what you have to do. So it works, but that's kind of, you know, it's a different piece.
Jillian's amazing. So, you know, it's all about trying to get it right, and I think we're very blessed to have arbitrators like Jillian to do that. So but I also think it shows how difficult it is to resolve these disputes in small claims court or otherwise for various reasons, right? I mean, it's beyond the money, it's beyond finding the right attorney. There's so many complex factors. Yeah, please.
What's your average dispute, like the amount in dispute?
About $3,000. But a lot of that's related to the partners we work with. So, you know, car damage for Turo is going to usually average out something like that. Yeah, but we've handled up to $55K on our platform. Tanaz, do you know?
$20.
Sometimes that's when people get the most pissed.
John, thank you so much for sharing your perspective on this. It's super interesting, and you said something really interesting that I'd love to follow up with you guys about. This sense of like, I just don't want any more letters, or I want to be done. Yeah. And I'm very curious, because what you're describing sounds a lot like a European model, like what a magistrate in the German system does, as I understand it. I'm very curious how coming out the other end of this? Because I went to small claims court and I lost, and I'm pissed about it 15 years later, which I'll talk about when we get drinks. But what do you see as your guys' role? I don't know, because judges just say, look, you lose, goodbye. There's 10 more people waiting in the hallway, go away. What do you guys see your role as educating people about, like, look, you don't owe them the 20 bucks? Like,
Yeah, so, I think the biggest thing with FairClaims is that we want our users to feel heard. We want our users to state their case, provide evidence to bolster their argument. And so what we do is we inform our users throughout the process, as Jillian has mentioned, whether it's as soon as both parties sign up, we send them an automated email that sends them to a page that says, these are the types of evidence that will be beneficial for your argument. And then it just continues in the hearing. Our arbitrators will sometimes suggest evidence or pieces of evidence to upload afterwards. And so unlike the court system where your hearing is it and you're going to receive a judgment, with FairClaims, you have 48 hours to upload additional evidence. So it's just an additional opportunity for users to feel heard, to have the opportunity to upload evidence and statements. And another key piece to this is an arbitrator providing reasoned decisions where the math is broken down, whether they point to things that were said during the hearings and touch on those points. So we want to ensure that our users are in the know about everything we're doing, but also why the decision was the way it was.
And just to add to that, and I don't have to deal with the complaining, but I absolutely know that the losing party reaches out and is really upset. But that is one thing just in my decision. I mean, I think they're typically like 3 pages. I don't know what the average is of awards, but it's less about, it's not like a brief where you're just doing a bunch of case law. I absolutely have had to do research and familiarize myself with what each state says, an opportunity to cure for contractors and things like that, and damages. But it is, I like literally break it down and just have to, I go over what each side testified to, and then it's did they give an opportunity to cure, and then I break down the damages and really try to explain. And sometimes even in the back and forth with the post-hearing evidence, if I have follow-up questions, like with the Wood lady, I said to her, you will not receive consequential damage. I flat out said it. Sometimes I'm very clear, and it goes to both sides. So, again, I think she's exactly right. I think it's if they, A, felt heard, and then B, as long as the award really explains it, I don't know if that takes away the anger that the losing side has, but, it helps.
It helps. The biggest complaint we get is if somebody doesn't understand why they lost. That solves for a big part of it. But you're always going to have some people who are unhappy they lost, but we try to make that as minimal as possible. Yeah, please.
Do you guys only do arbitration, or do you also do like the whole self-resolution process and mediation as well?
We also do self-resolution and mediation in our smart settlement tool. So about 1/3 of people resolve things on their own through that tool. And then about 2/3 right now with human mediation, but the idea is over time it'll be even more and more automated. But I personally firmly believe that there's no replacement for human wisdom. You can't automate human wisdom, in my personal opinion. So I think, yeah, exactly. So I think that'll always be at least part of the funnel. I think there was a question back there, and then we'll go.
Quick question, at scale, understanding where you're at now, with you're going to grow, have confidence in that. How are you going to vet your neutrals to grow your roster? How are you going to choose which of those neutrals to assign to which type of case? And how are you handling language translation or language issues?
What's Naz? You can speak to that.
Yeah, so that was a 3-part question, so I'll tackle it one by one. In regards to assigning arbitrators to disputes, we want to minimize the perception of bias, so they're randomly assigned. And moving forward, we hope to bring on more specialized arbitrators who can handle certain types of disputes. And then in regards to translators, we have no problem bringing on third-party translators to help during the hearings and or translate any evidence as well.
We take about 7% of arbitrators who apply. So there's at least 1 or 2 calls before a mock hearing. Then after the mock hearing, and by the way, for the mock hearing, they look at real evidence and have to have a combination of great pedigree and background, but high EQ to make people feel heard, but control the room. And then we have surveys on every single hearing. We have a FairClaims rep on every single hearing. We also have a scorecard that we keep, so that helps ensure quality. The other interesting thing is you don't have to be a lawyer to be an arbitrator, and so I think there's an opportunity there to get experts to arbitrate. Maybe we should, talk, but there's many ways to grow the system, and then we have a part of our software can assign arbitrators to cases based on who our partner is, and over time it'll be more and more of an algorithm.
On the language, I've had several hearings with translators, so the parties knew and had a translator. I speak Spanish, and one time it was just easier because the English, so we just did it in Spanish. But I think I've definitely had a handful where they just come with a translator.
Martin. Yeah, that second question is super interesting. On the first question, companies are adding us to their terms, so it's all public, so I can say it. Turo, Pure Space, Outdoorsy, several companies have us in their terms. A number of small companies have us in their terms. A waste management company in Texas said they had to go to small claims court like 3, 4, 5 times a year and added us to their terms. So another company, Laserway, is now adding us to their terms. So it's interesting. But on the enforcement side, that's been really, really challenging. So at least for the portion of people who don't pay. The best thing that ever happened was when we got the initial results on who does pay. Because they were opting in, it's tougher when it's mandatory enforced. But when people opt in, they pay up 85% of the time. That was like shocking to me. Like, first of all, I wasn't sure anybody would ever opt in. It was one of our partners who suggested it, and I was skeptical, and then it worked. And then it was shocking that they paid at such a high rate, right? And there were different carrots and sticks there as being part of the community, but I think it was just psychologically they respected the judgment because they volunteered for it. The mandatory piece is tougher, where it's closer to what small claims court looks like, but we're making a lot of breakthroughs in how we enforce. The biggest thing was so simple. It was just giving an enforcement packet to the claimants, explaining the process. Here's what you do. Resources, right? Not like actual legal advice, but some resources. And then having a packet that they could hand to the court clerk. It was that simple. And then all of a sudden, we had no issues with it. So initially, we used to call the court clerks and tell them who we were, and they had a million questions. And then we got feedback from one judge, and he said, here's why I can't do anything with it. And he listed out like 4 or 5 points. And we said, you know what? All that stuff is in our arbitration award, but it's not clear enough. It was a design thing, making it just easy for the court clerks. And now we're calling state to state. We're calling all the administrative offices and getting ahead of it and sending letters out. So it is a 2-step process still, where you got to get the confirmation of arbitration award and then go to the sheriffs to collect. But we're, first of all, at least making it easier for them to actually do it. They can then get paid back for that expense. And then at some point, maybe LegalZoom wants to join us. We can lobby to make that easier. So we'll see.
One thing I do as an arbitrator on that is if it comes out that the side who's going to lose, and I don't obviously state my decision during the hearing, but if I can tell that the side likely to lose does not look as though they're going to have the funds to pay $2,000, I will just ask both sides if they're amenable to a payment plan. Should I award, and what would the claimant be willing to do? And so oftentimes, especially in the car disputes, when these are Lyft drivers, in my award I set out a payment plan, and I make it very clear, and I basically say if there's a default on the first one, the entire amount is due by X date.
Great. I think we'll take one more question in the back and then get back to drinks and food. We outsource it. We use Heroku. We use Heroku and AWS. We have really strict processes. We're getting SOC 2 compliance. So we treat all it very seriously, but mainly it's just taking advantage of outsourced security layers. Yeah. All right. Well, thank you all for your time. Yeah.